Is there anything good in this proposed legislation? No. So between Springerville and up to our boundary, what would be appropriated would be 60,000 acre-feet to ranchers, cities, power plants, until it gets to Navajo. So Springerville to here. When it gets to our boundaries, we're going to get a right. We get the right of all unappropriated water. And the estimate is 160,000 acre-feet. We get 100,000 more than everybody else. And it's stated that currently Navajo uses about 38,000 of the water currently. If we're going to claim more, you want us to go for more than 160,000 acre feet, we're going to have to start taking away from somebody here. That may be a tough fight, because we're only using 38,000 right now. And we're getting 100,000 more than everybody else. To me, I think it's fair, Percy. What are some of the other possible benefits to this? Protection zones located near our boundaries so that the city of Flagstaff, Winslow, other non-Navajo entities can't start drilling more water. They can only be limited as it gets close to our boundaries, because there's the sea aquifer that we're going to be possibly using. We get a right of using the sea aquifer, unlimited use for residential and municipal, that means city use. To me, that seems fair. The N aquifer, we also get unlimited use for residential and municipal. There is a stipulation for the N aquifer that you can only have industrial use up to 2,000 acre feet. Problems with our N aquifer possibly being overdrafted. We have, the Delcom Loop pipeline. Now there's an NTUA infrastructure already established, but they only get alluvial water. That means shallow depth. And when it's a drought, kind of like it will probably be this summer, there may not be enough to serve those communities. And there's about 411 acre feet that are used and 431 acre feet for the Loop Delcom infrastructure that NTUA has now. With this pipeline and drilling, it's going to go to over 4,000 acre feet. More than about 10 times more capacity, so that they will have sufficient water. Also, the Ganado project, very similar. It's expanding the capacity to actually meet that NTUA lines that are already there, because they only get alluvial water. About $125 million for the Loop Delcom project, and we're getting $73 million for the Ganado project. That's a good thing. Nicole suggested that we need to ask for essentially more farming. Well, maybe we should ask for money to be able to dam this up so that we can maybe begin some agriculture, some tourism. Maybe. There's also the farms here currently, and the Loop farms. But there's certainly capacity for possible another NAPI 2 in this area. So asking for more may be a good idea, certainly to make more use of this. Okay, what are the problem areas? Because I don't have a lot of time. The problem areas are section 1314 and section 1317. 1317 talks about Peabody, and it's basically lease language. 'Peabody is not a party to this settlement. So why is Peabody's lease language in our water settlement with all these other entities for the Colorado River Basin? It shouldn't be there. The language specifically says that, they have rights to impoundments, permanent impoundments that already exist. That means they have sediment ponds to protect, their contamination of the water. And they're able to relocate their impoundments. But there's one little section in there that's terrible. It says that that the U.S. and the tribe would not be allowed to challenge them in any judicial court or proceeding. If they damage something, even in the SMACRA laws, which is related to mining, any judicial proceeding can mean everything if they contaminate or damage the washes. So that's something that has to come out. And so personally, if we can take that out, if we don't take it out, then I'm not going to vote for it. Okay? In section 1314, that's where it talks about Navajo Generation Station. And it has in their language that says, and it's almost essentially lease language again, that NGS will have available 34,100 acre feet available for essentially the life of NGS. They're trying to get a lease out to 2044 for 25 more years here before their lease ends in 2019. And then it says, including coal transportation and ash deposit. Now, certainly we could get rid of the coal transportation and ash deposit. Now, the first question I had when I met with Senator Kyle was, can we amend this document to maybe get rid of section 1317 and 1314? And he said yes. And so getting out the Peabody language is fairly easy. But when I asked him about 1314, he said, yes, you can do it. But there's something that's tied in with this. There's this Navajo-Gallup pipeline project. And there's 6,411 acre feet reserved by the Secretary to be able to help settle water rights. And that was done when they settled the Gila River water settlement. There was an allocation of 6,411 provided to the Secretary to help settle future water rights. When they settled this San Juan River settlement, Senator Kyle wanted to make sure that 6,411 acre feet could potentially cross state lines and benefit Winter Rock. So in the language of this river settlement, it says, if you settle the Colorado River and the Little Colorado River, then this 6,411 acre feet becomes available through this pipeline for Winter Rock. So basically says if you say no to the NGS, you're essentially going to say no to the 6,411 acre feet for Winter Rock. If we say no, and Catherine Benally has already initiated legislation or resolution to say no essentially to both. So the council will be making that decision. That way, NGS and Peabody are out of the picture. Again, we get 160,000 more acre feet. That's a good thing. We get unlimited use to the sea aquifer, the Ann Aquifer. We get about $200 million in infrastructure development. We may want to request more. We may want to reduce the amount for industrial use on Ann Aquifer. We may want to request more for farming, but that's kind of where we stand.